You've found Ask Alice, the podcast that takes a deep dive into the societal currents shaping our lives. We'll explore the often unseen forces at play, go beyond the brief, and examine the research, dissect the data, and most importantly, if you're seeking to understand what's shaping our society, this is the place.
Welcome back to The Deep Dive. Today, we're jumping into a really significant legal ruling out of California, a big one.
Yeah, definitely making waves.
Our goal here is simple. Break down how this state law got challenged, what the courts decided, and importantly, what it means for you.
And the headline news. The Ninth Circuit Court of Appeals just issued a unanimous decision. This was June 20th, 2025. They struck down California's one-gun-a-month law. Said it's unconstitutional.
Okay, unanimous. That's striking. Let's dig into the law itself first. California's one-gun-a-month rule. What exactly was it, and how did it evolve?
Sure. So it's officially Penal Code Section 27535. It actually started way back in 1999, but back then it was just for handguns.
Ah, okay.
Yeah, then fast forward to 2024, and they expanded it to cover all firearms.
Mm-hmm.
The state's stated goal was, primarily about stopping straw purchases.
Straw purchases, where someone buys a gun for someone else who can't legally own one.
Exactly. And, the broader aim was reducing gun violence overall. That was the justification.
Makes sense on the surface. But then came Bruen, the 2022 Supreme Court decision. How did that case just completely change the game for laws like this one?
Oh, dramatically. Bruen was a bombshell, really. It essentially tossed out the old-way courts, looked at gun laws at sort of balancing tests between public safety and Second Amendment rights.
Right. The balancing test is gone.
Gone. Replaced by a much stricter standard.
Yeah.
Text, history, and tradition. Now, for a gun law to be constitutional, the government has to show it's consistent with the nation's, historical tradition of firearm regulation. It needs a historical analog, basically.
A historical analog. Not just a good reason, but actual history backing it up.
Precisely. Good intentions aren't enough anymore. The type of regulation has to have roots.
And that brings us to the lawsuit, Nguyen v. Bonta. Started back in December 2020, individuals, groups like SAF, FPC, they argued this one-gun-a-month law violated the Second Amendment under this new framework, right?
Well, initially under the old framework, but Bruen came down while it was pending and really shaped the final arguments and the court's analysis.
Okay, so how did the Ninth Circuit apply Bruen here? What was their reasoning for saying unconstitutional?
Well, first off, the panel was unanimous, like we said, affirming the lower court. They stated pretty clearly that the Second Amendment protects the right to possess multiple firearms.
Multiple. They focused on the plural arms.
They did. Points right to it and said the amendment protects against meaningful constraints on actually acquiring those arms.
Okay, so protects getting more than one gun. And then the history part, the analog.
Yeah, that was the real kicker. The court said California couldn't point to any relevant historical analog for a law limiting how many firearms someone could buy in a specific time frame. They said the state couldn't even find a historical cousin.
No cousin, huh? So the state's arguments about things like old gunpowder storage laws didn't fly.
No, the court shot those down. Said the purpose was totally different. Those laws were about safe storage, preventing fires, things like that. Not about limiting the act of acquiring firearms on a schedule.
And the court also used this phrase, temporal metering of rights. That sounds pretty stark.
It really does. And they strongly rejected that idea. They used some powerful analogies basically asking, could the government limit your free speech to one protest a month?
Wow.
Or limit your freedom of religion to one service a month? Their point was that the delay, the metering itself, was the core of the law, unlike, say, a background check delay.
Right. A background check delay has a specific purpose verification.
Exactly. An administrative function. Here, the Ninth Circuit said the time limit was the regulation, and that kind of metering of a fundamental right just isn't constitutional without historical precedent.
Okay, so let's get practical. What does this mean right now for people in California, and maybe for other states?
Immediately. Law-abiding citizens in California can now purchase more than one firearm, handgun, or long gun within a 30-day period. That restriction is gone.
And the ripple effect?
Well, this ruling definitely puts similar laws in other states. And there aren't many. These were already outliers on very shaky ground. They'll face the same Bruen challenge. Show us the historical analog. And they likely won't find one either.
I remember reading about a California bill, AB 1078, that tried to maybe change the limit to 3 guns a month instead of 1. Does this ruling kill that idea too?
It certainly seems to. Judge Owens wrote a concurrence, making it clear that while this specific law failed, the ruling doesn't stop states from using other historically supported methods to combat things like straw purchasing.
Correct.
But the core reasoning against temporal metering, arbitrarily limiting the number within a time period, applies whether the number is 1 or 3 or 10. Without historical backing for that kind of limit, it seems any version of it is likely unconstitutional under Bruen and this Ninth Circuit ruling.
So wrapping this up, the main takeaway seems pretty clear. The Second Amendment, as interpreted through Bruen, protects acquiring multiple firearms, and states trying to regulate that face a very high historical bar. That's it. And it leaves us with a big question, maybe something for you to think about. How will states respond if these kinds of limits are off the table? What historically grounded approaches might they explore or maybe rediscover to address public safety concerns while respecting Second Amendment rights as the courts now define them? It's a new landscape.